Receive your reprimand. Mr. Norkin, you're here before the court today because of ethical misconduct in your professional life as an attorney. And I must begin by saying how sad a day this is for you, for us, and for the entire Florida Bar. At the most fundamental level, you have repeatedly shown behavior so serious on so many occasions that this court felt it necessary to command you to appear today for a public reprimand. This is a very serious matter, Mr. Norkin. It's very unusual for any lawyer to be reprimanded in person before the Supreme Court. That fact alone underscores the gravity of your situation. The effectiveness of our legal system ultimately rests on the trust and confidence that the people confer upon the attorneys who practice in our courts. And that trust and confidence is seriously undermined by the grossly unprofessional actions you have exhibited. That is why we have ordered you to appear today for a public reprimand that's being broadcast throughout the state. It is one way we can assure the public that we take the lack of professionalism by a lawyer very seriously, and that we will not hesitate to punish errant attorneys in the most public way. Mr. Norkin, this court, in its opinion, has found that you have continued to engage in rude and antagonistic behavior in judicial proceedings despite repeated warnings from judges. You have disrupted proceedings to such an extent that it was impossible for the presiding judges to conduct hearings, and the transcripts are very clear on these points. Despite the record evidence against you, Mr. Norkin, you have denied the patent lack of respect you have shown to others involving in these matters. Further, you have falsely accused a senior judge of having a conspiratorial relationship with opposing counsel, an allegation that, if true, could have subjected that judge to ethical or criminal investigation. And the referee hearing your case concluded that these allegations not only were false, but that you knew them to be false, and you used them in an effort to obtain an advantage. Your conduct toward opposing counsel has been equally egregious. You have subjected counsel to harsh treatment and justified the actions solely because of the conflicting interest of your client and the opposing client. No attorney is justified in such conduct because, as the guidelines for professional conduct state, effective and zealous representation does not require antagonistic or acrimonious behavior. Even in the present disciplinary case, Mr. Norkin, you have disrupted several hearings by yelling at judges and exhibiting other disrespectful conduct. Yet this is only a part of a pattern of similar unprofessional conduct you have shown in other cases as well. In fact, you previously have been reprimanded for the same category of misbehavior that brings you before this court today. The fact that you have reoffended weighs heavily against you, Mr. Norkin. The tirades and antagonism you have shown in this and other forums has persuaded us to reject the referee's recommendation of a 90-day suspension. Your escalating pattern of abuse and unprofessional conduct will and must come to an end. Accordingly, we have imposed a sanction of 2-year suspension, thereby requiring you to prove rehabilitation before you can be restored to full membership of the Florida Bar. For these failings, Mr. Norkin, you are hereby publicly reprimanded for your misconduct, and a suspension is imposed upon you in the manner described in this court's opinion. You're now free to leave. This court is in recess for 10 minutes.